Namaskar. I am Dr. Nalini Avinash Wagmare, working as Associate Professor at Tilak Maharashtra Vidyapit, Pune. Today's our topic is related to justice under the Vijayanagara Empire. What was the judicial administration under the Vijayanagara king and rulers? So there were regular courts that handles justice in various regions of the empire. They had a hierarchy of officials in charge. In addition, there were village courts, caste panchayat, and guild organization to handle minor offenses like breaking trade and caste laws. Under justice, while we are studying detail about the justice under Vijayanagara, the Dharma Shastra was the Shariat of the Hindus. If the Shruti was revealed knowledge, like the Quran, the Smriti contained the traditional ruling like the Hadith. The Vedas, the Dharma. Namaskar, I am Dr. Nalini Avinash Wagmare, working as Associate Professor at Tilak Maharashtra Vidyapit. Today's our topic is related to judicial administration of the Vijayanagara Empire. There were regular courts that handled justice in various regions of the empire. They had a hierarchy of officials in charge. In addition, there were village courts, panchayat courts, caste courts, guild organizations to handle minor offenses like the breaking trade and caste laws. Uh, the Hindu society was divided into number of castes, subcaste, and other sectarian groups. Each of these segmented groups had its own set of unwritten laws in the form of customs and traditions. The Smritis ought to accommodate all these customary laws with their innumerable variations. They reflected the society of their times. With the change in circumstances and with the passage of time, the Smritis had to be interpreted and reinterpreted so as to suit the changed conditions. Hence, there came into existence the celebrated commentaries and the law-giving digests such as the Mitakshara of Vijayaneshwara, Parasara Madhyaviyam, and the alike. Briefly, the Hindu law was not derived from the legislation. It was originally derived from the revealed text and later interpreted, not changed, with reference to the customary laws. As it was not made by man, so it could not be alterated by man. The king was really speaking not the lawmaker. He was only the enforcer of laws. The importance of punishment as a means for maintaining social solidarity and security was stressed by the medieval Hindu lawgivers. Danda or the just infliction of punishment according to the Smritis and well-established law was considered to be one of the essential duties of the king. Krishnadevaraya, Basavaraja, Ramachandra Pant Amatya have all brought into relief the importance of administration of justice in their work. Parasara Madhyaviyam. The Vijayanagara monarchs, although guided by the uh, Parasara Madhyamiyam in their judicial administration in general, it seemed to have disregarded some of the salutary injunctions laid down by the ancient and medieval jurists. About the nature of law and punishment, about the general nature of law and punishment, they have stressed two important principles. The first is the inevitability of infliction of punishment for the maintenance of law and order in the state. At the same time, they declared that the punishment shall be just and moderate, not unwarrantably severe. This was the second principle. It shall be in other words, tempted with the mercy. According to Kautilya, severe punishment makes the king repulsive. Mild punishment makes him contemptible. Just punishment makes him respectable. So, what is the importance punishment by the jurist? When we come to the medieval times, we find the same emphasis laid on the importance punishment by the jurist. Krishna Devaraya says in his Amukta Maulida book, which was written by him, he says that the wife's attachment to her husband, the proper relation between men and women, the ascetic subduing his indriyas, the lower caste showing deference to the higher, the servant looking carefully to the interest of the master, You should know that all these are brought about ultimately by the fear of the king's punishment. So punishment is important stated by this in the Amukta Maulya. Then Vidyaranya, he says that it is impossible that the Vyavahara Khanda of the Parasara Adhyaviyam, a commentary written by Vidyaranya on the Parasara Smriti, had influenced the judicial administration on Vijayanagara. The Vyavahara Khanda, a chapter on the administration of justice, Vyavahara was added to the Parasara Smriti by Vidyaranya while commenting on it. Although Mahalingam says that Vidyaranya was not the Kautilya of Vijayanagara and that his commentary, especially the Vyavahara Khanda, was not meant to be a code of law for the Vijayanagara courts, yet it seems that it had considerable influence on the judicial system of the Vijayanagara. As is proved by the inscriptional and other evidence, remarks that the minister and spiritual preceptor Vidyaranya composed a work on law and government. It was intended as a manual for the officers of state. Is founded on the text of Parasara with a PS commentary by Vidyaranya. A court of law was styled the Sabha. A court of law was styled the Sabha. The Sabha was of two types, Mukhya and Amukhya. The Mukhya court was one that sat regularly, otherwise it was Amukhya. A Mukhya court means importance one. A Mukhya court could be again of two types, Pratishtita, Apratishthita, that is stationary or circuit court. Both the Pratishtita and Apratishthita courts could be either Kshatriya courts or Mudrika courts. Means division of courts was found in this system in which was existing in Vijayanagara times. If the king personally presided over the court, it was termed Sastriya. If a judge appointed under the seal mudra of the king presided, it was known as Mudrika. So king's seal considered. Then the Chief Justice and others, the highest court was situated at the capital and exercised both civil and criminal jurisdiction in the whole of the empire. Besides the emperor who acted as Chief Justice, the judicial bench consists of a Pradavivaka or the pursuit judge and Sabhyas, who were generally two in number. Other members of the judicial staff were the Lekhaka, or the writer, or the bench of clerk, Ganaka, the accountant, Sandhyapala, the court bailiff. The Lekhaka recorded the oral evidence produced by the litigants. The Ganaka calculated the amounts involved in the lawsuits, and the Sandhyapala produced the litigants and the witnesses before the court and maintained order and discipline in the court. The king could appoint his representative style Pratinidhi to preside over the court. Dandanayaka. From the actual records, we know that the emperor was the chief justice of the empire. But generally, an independent officer acted as chief justice on behalf of the king. He was called Dandanayaka. About the office of his chief justice, Abdul Razak also gives some information about this. According to him, Dandanayaka was seated on a raised platform. On his either side, but slightly below his seat, stood mace bearers in two rows. The litigants approached him in between the two rows of mace bearers, offered some presents, made obeisance, and then presented their case to him. Thereupon, the Dandanayaka gave the judgment in accordance with the rules of justice prevailed in that time. This was considered to be final and there was no appeal therefore after it. The designation Dandanayaka, though it sounds a military term, was civil title bestowed on many high officers of the state. The Chief Justice was one such. In Keladi and Mysore, the king himself acted as a Chief Justice, whereas in Mathura, the Pradhani generally controlled the Department of Law and Justice and sometimes formed a judicial bench along with the king. Yet the final authority in legal matters rested with the king. There is not enough definite positive evidence throwing clear light on the Supreme Court or the Office of Chief Justice in Vijayanagara time. Dandanayaka administered justice independently. Whatever evidence is available shows that sometimes the king himself dispensed justice in person. Sometimes he asked some of his officers to try cases. Sometimes both the king and the Dandanayaka administered justice independently of each other, as Nunes would have us believe. Sometimes he ordered that the case be decided by the arbitration. Sometimes the king sought the advice of the learned Brahmins attached to the famous temples. In the provinces, the provincial governors dispense justice on behalf of the king. In local areas, the caste elders, the panchayats, the temple trustees, the village assemblies, the guild court administer justice largely on the basis of the prevalent customary laws. Then Dharmasana. A record from the Anantapur district shows that the village court, Dharmasana, consists of the chief men of the village and the Iyengars, or the village servants, decided a case relating to the claims of two rival claimants over the office of the village headman, Gaudike. In the far south, there were some special judges called the Samayacharas, the Saharis, who administered justice in social and religious cases. These were the censors of morals compared to the Sardars of Mughal India. They were appointed by the government. The office was formed out on contract in all the large towns. No religious ceremony or marriage would be undertaken without the permission of the Samayacharas. Then other laws in which existed in Vijayanagara time. Beside the Sikh law, the Vijayanagara judges applied some other laws such as the law of treason, law of limitation, the law of service in arms. The punishment of treason was execution. The treason could be either against the king or against the Sangha association or Samudaya community. The law of limitation sign that a given piece of land or some other property held under mortgage by a mortgagee had to be returned to the mortgageor after a certain period, generally after 12 years, even if the owner was unable to pay the amount of the mortgage. The law of service in arms laid down that lands granted as service in arms shall not be alienated by the guarantees. Then importance of punishment. The Baswaraja brings into relief the importance of justice punishment by declaring that the king should punish not only the wicked men, but also wicked birds and beasts. He tolerates no idea of the oppression of the subjects by the king. He says that fire issuing forth from the downtrodden subject will not turn back until it was burned the family, fortune, and life of the tyrannical king. The Kerala lawgiver has dealt with land rights, debts, succession law, lawsuits about animals, food grains, cloth, liquids, interest, fines, witnesses, punishment, ordeals, and oaths, division of property, boundary disputes, water disputes, cheating, etc. It is possible that his injunctions regarding some of these titles guided the Keladi rulers in their administration of justice. From epigraphical sources, we know that the law of treason, the law of succession by which the property was inherited by the males through females, and the law of exchange were administered in the Keladi state. Then various type of cases find in that time. In some cases, High Minister of the state preside over the judicial proceedings. He, together with some councillors, consist an integrated court. While deciding cases, the evidence of witness was taken. The government charged court fees. Some lawsuits could be directly taken to the King's Court. Various types of cases, such as those relating to the debts, loans, bribery, unlawful discounts dedicated by the money changers and money lenders, falsehood, hypocrisy, theft, debauchery, corruption were decided in the court of law. The punishments awarded included seizure of the children of the culprit, fines, mutilation, imprisonment, and execution. Then security of the people. Speaking of the security prevailing in the state, Alexander Hamilton remarks the subject of this country observed the law so well that robbery or murder are hardly heard of among them. Jacobs writes about a highway in the state that it was so secure that any stranger might go and sleep there with bags full of money, and nobody would molest or rob him. Then Niyogi. Niyogi means a lawyer at that time. In civil cases, the litigants were allowed to send their representative called Niyogis to speak for them. Their statements were considered to be those of the litigants whom they represented. The Niyogis could be compared to the modern lawyers. First, the statements of both the plaintiff and defendant were collected. The document containing the complaints of the charges made by the plaintiff was known as the Pratijna, and the answer given in writing or the statement of his case by the defendant was the Uttaram. Then litigants. The court thereupon examined the statement of litigants and the evidence of the witnesses. The court tried to get the truth in given case by a searching examination of evidence given by the litigants and their witnesses, either oral or documentary or both. And if this evidence was found insufficient, then they had an appeal to the supernatural power. They sought to get the clue from these powers in the ordeals which were of different kinds and which were restored to only in extreme cases, and that too when all human efforts failed to unravel the mystery of the cases. Then Jayapatra. Finally, the judgment was delivered in a document called the Jayapatra, signed by the judge and probably by the brother Vikvaka and Sabhyas also. The emperor, during his tour, held circuit court in the provinces. Permanent stationary courts. There is a reason to believe that besides the Aparatishthita courts, there were Pratishthitas, permanent stationary courts in the provinces. These courts had both original and appellate jurisdiction. From the local records, we know that one Allamaraju filed a suit before the court, Dharmasasana of Kaveri Samudram Agrahara, against the right of his cousins to the Karinikaris of certain villages. The court gave the decision in favor of his cousin. Mallamaraju therefore appealed to the governor of the provinces, who consists a court of Dharmasasana for the purpose. This court went into the case and gave a judgment in favor of Mallamaraju. Evidently, the decision of Dharmasasana of the Kaveri Samudram Agrahara was reversed. Then local courts also existing at that time. The institution of court was a permanent feature only at the center and in some important towns. In the local areas, there were generally amukya or the temporary courts set up as and when the need arose and were dissolved after its work was over. These local courts consist of the local leaders who sat in judgment over the local cases. This was in keeping with the injunctions of the Parasara Madhyaviyam, which declared the hillmen should be tried by courts composed of hillmen. The soldiers should be tried by courts composed of soldiers. Merchants should be tried by courts formed by the merchant. Caste disputes should be settled by courts consisting of caste elders. The disputes among the villagers should be settled by the courts presided over by the villages. These courts were mostly arbitration courts. Then Mahajans. The parties to a dispute were often required to go to the Mahajans of the neighboring Agrahara or to the members of merchant guild for getting their disputes settled. In the Dharmasasana, each litigant would first submit an affidavit-style Vyavahara Patrika containing a statement of his side of the case and Pratijna Patrika pleading that they would abide by the decision given by the court. After the case was tried, the court gave its decision in a document called the Jayapatra. This practice of taking the cases for a trial and decision to the courts of the neighboring Agraharas or merchant guilds was similar to the one prevalent in medieval Maharashtra. Then in civil cases, the judicial procedure consists in arbitration, in the examination of evidence, documents, and the statements of witnesses. In trials and orders such as dipping the hands of the accused into a pot boiling ghee or in a trial by jury. We may note a few details about some of these methods. An inscription coming from the Sira Taluka of Tumkur district contains the rules laid down by regarding judicial procedure in certain cases. The king laid down, if a caste dispute arises in the country, then will summon the practice parties before them and advise them. And as they have the power of punishment, the parties must act according to the advice given. This proceeding is to be free of cost to them. An interesting instance of ordeal of ghee is recorded in the epigraph coming from the Mysore state. According to it, there was a dispute between barbers and washermen on the one hand and the potters on the other regarding the claims of later to the paring of toys and nails and trying to upper clue. The first party denied this right of the potters, but the latter insist on this right and won the dispute by undergoing the ordeal of dipping their hands into the boiling ghee before the god Divya Lingeshwara in the Harananahalli. Niccolo County also visited at that time, and the contemporary authority speaks of three kinds of ordeals that were employed in the judicial procedure in Vijayanagara in trying the criminal cases. The litigants were asked to undergo the ordeal after swearing if there was no evidence of the witnesses forthcoming. What was these three type of ordeals? There were three kinds of ordeals. In the first, litigant, after taking the oath of innocence before a deity, licked with his tongue a piece of red hot iron. In the second, after taking oath, he walked a few steps before the deity, holding a red hot iron plate in his hand. The third ordeal was the ordeal of ghee, which was his county was the most common to all. A pot of boiling ghee was placed before the deity. The accused dipped his two fingers into the boiling ghee after swearing that he was innocent. Immediately his fingers were wrapped with cloth and seal was stamped on it to ensure that it would not be removed till the prescribed time limit was over. On the third day, the covering was removed. In all these cases, if the accused was found injured or hurt after the ordeal, he was declared guilty. If not, he was acquitted of the crime. Sukracharya speaks of the following seven ordeals. Sukracharya speaks of following seven or fire, poison, vessel, water, virtue, vice, rice, or wood. The fire ordeal can be of different kinds, such as the hot air ordeal, burning charcoal ordeal, hot oil ordeal, etc. About this Sukracharya, the accused has to walk 7 steps on the hot charcoal, has to take out a quantity of iron, place it in a hot oil by the hand, has to lick by the tongue a very hot iron plate. If news is to be believed, the Vijayanagara rulers made use which for tracing the culprit. Then punishments also existing at the time. Various kinds of punishment were inflicted on the convicts, ranging from fines to execution. The severity of punishment was not always proportionate to the gravity of the crime. Sometimes the light punishment were prescribed for grave crimes, at others severe punishment for ordinary crimes. From an inscription of Rangivayam in the Pudukkottai state, we learned that the rate of fines for an assault in that area was 5 panams if the victim was a male and 10 panas if a female. The different type of punishment, this punishment was awarded to a man for outgoing honor of a respective woman or girl. For murders and some other crimes, the heads of the guilty were cut off in the marketplace. Nobles guilty of treason were in place alive on a wooden stake thrust through the belly. The punishment of killing a victim by causing an elephant to tear him to pieces was also prescribed at that times. Imprisonment, exile, blinding, torture, confiscation of lands were some other punishment mentioned in the records. So, on the strength of accord, Nunis Malingam, all men were not equal before the law, some getting more severe punishment than others for the same kind of crimes. So, mention that one also. Miscarriage of justice under Vijayanagara. Muktamola state that sometimes there was a miscarriage of justice under Vijayanagara. The king, on some occasion, handed over the culprits to his guards without punishing them immediately, although their guilt had been already proved. If the convicts under the charge of guards escaped somehow, the guards would bring some others in their place and then punish them. The possibility of escape of the culprits from the custody of guards due to the corruption of the guard themselves may not be prevented. Then the police force. Under the Vijayanagara, there were two kinds of police forces, one maintained by the state, other by the people. The police force maintained by the state was stationed at the provincial district levels and also in big towns and cities, whereas that in the rural areas was largely maintained by the people who remunerated their services by grants of lands, by the payment of perquisites and the salaries, payable both in kind and cash. The provisional governors, the prefects of the towns, and the cavalagars, as well as talavaras in the village, were themselves held responsible for the detection of the crime. If they failed to produce the culprits, they were themselves penalized. All this seems to have a salutary efforts of this state. It seems to have gone a long way in maintaining peace and security in the empire. Great equity and justice are observed to all, not only by the rulers but by the people at one another, stated by Barbosa. So these are the reference book. You can refer for more detail. Only here highlighted the Vijayanagara uh, judiciary in Vijayanagara Empire time. Even some website also referred for this. Thank you.